And I put the transcript on there for the jury to see, and his response to that was, well, you don't understand because you are a virgin. And I was like, what did you say, sir? He's like, I said you don't understand because you are a virgin and you've never had sex before.
That's crazy.
And then the judge literally threatened to throw him in jail like 3-4 times after that.
All right, everybody, welcome to a special episode of Cases Gone Wild with me, your host, John Marco, and brought to you by Marco Law. We are live in downtown Detroit from the Michigan Trial Lawyers Summit, where lawyers have come in from all over the country to talk about their cases, become better lawyers, and learn from some of the masters. So we have a special show for you today. Instead of me sitting down for a one-on-one, we are going to bring you dozens of lawyers from around the country to share their craziest stories with you, who have been interviewed by my Cases Gone Wild team while I'm inside the conference here in Detroit at the Book Cadillac downtown, inside the conference presenting on various topics. It's a really cool, exciting show. We're going to mix it up for you today. So enjoy the show. If you like us, like the show, please make sure that you share with your friends and give us positive reviews and thumbs up. You can watch us live on our YouTube channel or on all of your podcast presenters. Without further ado, here we go. Dive in for another Cases Gone Wild.
So go ahead and introduce yourself, name, where do you work, and what kind of work you do.
My name is Gary Safer. I am a personal injury trial lawyer. I work for Morgan & Morgan in the Detroit office. I handle exclusively third-party auto negligence cases. I don't do anything else. But yeah, that's what I do. I spend a lot of my time on car crashes.
How long you been doing it?
God, this work I've been doing almost 8 years. I've been a lawyer for 13, almost 14.
So tell me about a case of yours that has gone wild.
I had one case, my last trial. It was a really tough case at my last job, and they gave me. I had this file with this elderly lady, really sweet lady and her husband. She was rear-ended about 10 miles an hour. So there was like hardly any damage to the vehicle. And she had no pain at the scene. And so you would think like she's not hurt. And so, but they're older and she's like, well, we should go to the hospital anyway. So her husband takes her to the hospital and they find that she has a compression fracture in her spine, but she had no pain at the scene. And so this case ends up in litigation. And then that's when it ends up on my desk. And I'm like looking at this case and I'm like, so what's going on? Like, what's the problem? What are your injuries? And she's telling me, well, I can't sew as much as I like anymore. And, sometimes my feet kind of tingle. And so in Michigan, with a threshold that we have to hit for injuries to show that you have a serious impairment of a body function, meaning that your injury's objective, that it's to an important part of your body, and that it affects your ability to live your life. I had a big hill to climb for this case to figure out, all right, first of all, what is your injury? And then second of all, is it objective? Is it affecting your life in any way? So I just spent a lot of time with this lady, really getting to know her. So when this case was being defended by Allstate, and they had house counsel on it and they did okay, but they weren't really taking the case seriously because they just didn't think she was that hurt. And so we went to her deposition and I had learned that she had done all these like sewing things, these projects for these little dolls that she loved. She would sew these for her grandkids. And so I brought them to the deposition and showed this to the defense lawyer. I'm like, wouldn't you agree that these are ornate? Wouldn't you agree that these are really hard to do? And she's like, yeah, I can't do these anymore. It takes me so much longer now. It takes me days to do these instead of an hour and a half, And so at that time I was starting to kind of figure out there's more to this case. There's more to this case than just, she had a compression fracture and she's got some tingling. There's some real stuff here that she's not telling me. So what happened was, I start getting more about this story and we get further into litigation and I'm trying to work it out with the insurance company. And I'm like, come on, get this lady some money. Let's try to resolve it because that, neither you guys don't want to go to court. And if you guys don't settle, it's going to get really ugly. And I was like, it's gonna. And they're like, okay, Gary, whatever. Okay, yeah, we're real scared of you. Yeah, We'll see ya. And so then things got really ugly. I ended up getting, I started really pushing on the gas for some discovery stuff. I ended up getting their witness list stricken. I ended up getting their affirmative defenses stricken. Their defenses are, what they're raising to say that even if what you're saying is true, we still win. So I got all of those stricken. And I got them so bullied that at some point they finally just said, okay, fine, we admit that her injury is a serious injury. We'll just try the case on damages somehow. And then, Allstate tries to call on another lawyer to try to clean up the mess. But by that point, the building's already on fire. You can't stop the burning. So we get to trial. In this case, I actually worked down with Samantha. And we get to trial, and they're already trying to offer the policy limits for this lady. And this lady's never had surgery. She has some orthopedic follow-ups. She's had a physical medicine and rehab doctor that she followed up with. This doctor is testifying. I don't know what's causing her pain. I don't know what's causing any of this. But I'm like, I got a stipulated order. You guys said it's a serious impairment. It means that you guys can't talk about that anymore. And we get to trial, and her husband, he looks like the guy from Up. He's telling this story about how he can't hug his wife no more, and how she used to run up to him and say, "I love you, baby," and he'd squeeze her and swing her around. Can't do that no more, he says. And she used to chop firewood, and I was like, "Yeah, you guys. When I went over to your house, you guys had these rolled up newspaper things. What were those?" "Oh yeah, we chop our own firewood, and we have a fire stove for our house." And we told this whole story, and then by then, the defense was just looking at me like, "There's no way." There's no way that this is going to happen. And we ended up getting a $400,000 verdict.
Oh, that's
so
incredible.
On a case with no surgery, not a lot of treatment, and really no answers for why she's having the problems that she's having. There was no disc herniation. There was no, obvious thing. There was this T2 compression fracture that may or may not, have been causing these problems. But yeah, that was a case that was wild to me, that, the result that we got. But I think when you tell somebody's story and you really try to get to know somebody, and realize that while an insurance company might, be minimizing it, don't buy into their propaganda. Don't buy into what they're trying to tell you about what your case is. If somebody's coming to you for help, it's your job to tell their story right. So that's my case.
That's
off
incredible.
The top of my head with no coffee.
That's incredible. It's a very valuable yarn doll.
Yeah. Any case can be won as long as it's righteous.
That's incredible, man.
Good morning. Thank you very much for having me. My name is Roger Foisey. I am a co-founder of Private Footprint. I'm an attorney also, and I'm from just outside of Toronto, Ontario, Canada. And really excited about being at this conference to be able to sort of talk about our product, because our actual product actually comes out of solving a problem. So in 2020, having practiced personal injury for more than 20 years, I had a problem with a client who actually posted herself jumping out of an airplane with a GoPro and posting that online for public to view. Well, the backstory behind that is that the client actually had an offer on the table from the insurance company of $800,000, and once they found that, they took that right off the table.
Absolutely, they would.
From that point, we just basically decided we've got a problem. So I contacted my business partner, Abby, and we built a product called Private Footprint. And what Private Footprint does is it provides law firms with access to their own clients' social media, permission-based. So it's like ordering clinical notes and records. So for $100, clients can actually grab all of their clients' social media evidence, as we would call it, 10 years back, and that's what we called the sword. And then the shield would be, it continues to allow them to access it for another 2 years going forward. So the idea is to actually help attorneys to get ahead of these problems, because the stories we have heard over conferences, and already a few of them here today, is just unbelievable. It's been very exciting.
Why don't you go ahead and introduce yourself for us, where you work, what you do, how long you've been doing it?
Okay. My name is Zach Runyon. I work for the Runyon Law Group. We do primarily civil rights work for plaintiffs. I do some personal injury and auto accidents, things like that, but it's predominantly civil rights work.
Nice. So why don't you take us through your craziest case that you've ever had?
So my craziest case actually just wrapped up a few months ago. It was a Jane Doe case, which is when a sexual assault victim doesn't want to put their real name out there because of what happened.
Right.
And my client, along with 5 other women, worked for this guy in Birmingham who had this sham operation where he literally set up a shell company where he said he did medical device sales. Didn't sell any medical devices. He would just bring in these young, attractive girls who were just out of high school, offer them a lot of money, but then would just take them out to lunch and try to date them and have sex with them. It was really disgusting, and he was able to do this for several years until we finally sued him and got it out there that he was doing this.
That's awful. So that was the outcome?
Well, we had to take it to trial.
You did?
And, I mean, the trial just got crazy. His defense for my client was that my client was a prostitute, and he was paying her to have sex, which just wasn't true in the slightest. But this guy was so deranged that he would rather go down in flames and bring my client with him than just admit what he did was wrong. And so right from the get-go, the jury hated this guy. But I think it really came to a head during cross-examination when I confronted him with the fact that he admitted in his deposition that he currently had one female employee that he hadn't had sex with yet, but he really wanted to have sex with her.
In his deposition?
In his deposition, and he denied saying that, and I put the transcript on there for the jury to see, and his response to that was, well, you don't understand because you are a virgin. And I was like, what did you say, sir? He's like, I said you don't understand because you are a virgin and you've never had sex before.
That's crazy.
And then the judge literally threatened to throw him in jail like 3-4 times after that. But
not surprised.
Yeah, so it ended up with a huge verdict. My client got $32 million.
Nice.
She was the highest of all the plaintiffs, but together with all the plaintiffs, it was $138 million.
Oh, wow.
So it was a good ending, but you know,
Absolutely.
My clients will still never recover from what happened.
Oh, no, absolutely not. No. Well, thank you for doing the good work, and congratulations on that impressive verdict.
Thank you.
So can you introduce yourself for us first and tell us a little bit about what you do and what kind of law or what you were doing before?
Sure. So my name's Dan Ambrose, and I run Trial Lawyers University.
Okay.
I'm from Detroit, and I practiced here until I was 45 years old. And I did, primarily 99% criminal defense. In 2012, I moved to California. And then in 2014, I started running like workshops and trainings. And then in 2020, I started Trial Lawyers University when the pandemic came along. And then I got to meet the greatest trial lawyers in the country and get to interview them and have them break down cases. And now I do conferences, podcasts, webinars, trainings, boot camps, that kind of stuff.
And I understand that you have your own crazy cases from when you did criminal defense.
Well, just one that was the craziest of all, but it happened right here in the great city of Detroit. It was this guy named Reginald Burks. He was accused of murder, and he was completely innocent, but he was basically framed by the police.
Oh my God.
Because they arrested the wrong guy. This guy named his name was I can't remember the guy's name, Quentin something or another. The police arrested the wrong guy. My guy Reginald learned that this guy was in jail because on the streets, people talk. And so he went to the jail. He went to the police, told them, hey, you've arrested the wrong guy. I was the one that was out there that day, but I shot in self-defense because they shot at me first. Here's my weapon. Here's my CCW. I'm a security guard, and what happened from there was they let go of the guy. They arrested my client, put him in jail, kept him there for about 3 months until he could make bail.
Oh my God.
But through the course of the case, though, what was the craziest parts of all was that it was a shooting, so it was a murder case, and it was the people who were in the van where the kid was shot. There was 911 calls reporting this van driving around the neighborhood, robbing people at gunpoint. And the police knew this, but they ignored all this evidence. And what happened was there was, this guy got shot, this poor kid, probably a 14 years old guy, shot in the head.
Oh.
And it was a foster child of the driver of the van. And what we proved happened was that and the back window of the van was blown out, right? So a bullet had gone through that window. and hit this kid in the head and splattered his brain.
Oh my God.
But what we proved was, I hired a blood spatter expert out of Edmonton, Alberta, and his name was Joe Slemko, because he was basically the chief of police in Edmonton, but part-time he was a blood spatter expert, but he didn't do it for profit. I only had to pay him like $1,000 to cover his expenses, what he would have made being a police officer during that time. And so he came and testified, and it was in front of this judge who was the biggest asshole anybody ever put on the bench. I can't remember his name, but because of the blood spatter, because like it's pretty obvious when you see it. If a drip hits the ground, it goes from big to small, right? A splatter gets bigger and smaller as it gets spread out. And so the drips, it was obvious from the blood, it was splattered that the shot came from the front and not from the back, because the way the splattered, it goes from front to back. The splatter will clear the bullet came to the front. Right. So we proved that, and the jury was only out like 20 minutes after like a month-long trial.
Oh,
so,
you got him off.
No.
Oh no.
We don't say we got him off.
Oh.
He was exonerated because he should have never been there.
Yeah.
That was a crazy case. Then after that, the judge filed the complaint. No, the prosecutor, who was I don't even think he's a prosecutor anymore, but just one of the most dishonest, worst human beings God ever put on earth. I can't even remember his name, but I just remember that because I whooped his ass so bad that he filed a grievance against me because I put it on Facebook, what a dishonest piece of shit he was. So that caused me some extra headaches over the time. But, and then I was canvassing the real rough parts of Detroit, like
Oh yeah.
for looking for witnesses. And people were looking at me like, driving through the neighborhood, looking at me like, what the fuck are you doing in this neighborhood? And I'm like, hi, I'm like, if you know about so-and-so, and they're like, it was scary.
Oh my God.
For me.
Yeah.
Because I don't have investigators and stuff. I am the investigator, so.
Oh my God.
So that's the crazy case of my life.
Well,
Reginald Burks, my one murder case, my last one, my first one, my last one. But then I ended up representing his brother. His name was Dewan Burks on an attempted murder charge because he shot 3 people with a sawed-off shotgun.
Oh yeah.
And I worked my ass off of that one, and he was actually acquitted. It was a good self-defense argument, but unfortunately that empowered him to think he was above the law. And like 2 weeks later, after he got acquitted of that, he went and robbed some poor guy at gunpoint and shot and murdered him, and took the guy's phone to the pawn shop and sold the phone. 2 hours later, and the guy was arrested, and he calls me up. He's like, "Can you help me?" I'm like, "No, my pro bono days are done." So the whole Burks family and I were like this at one point.
Yeah.
Now we've kind of drifted apart in the 10 years since all this, or the 14 years since I left Michigan.
Yeah. Well, thank you for sharing your story with us.
Yeah, so my name is Sarah Havens. I'm a plaintiff's trial lawyer out of San Diego. My office is actually Solana Beach, San Diego, California. I own my own practice, and I'm currently the president of Consumer Attorneys of San Diego, which is the local trial lawyers association in San Diego.
Nice. So why don't you go ahead and tell us about the craziest case you've ever litigated?
I don't take cases like this anymore. So, prior life, before I open my own practice and do what I want, I worked at firms that prioritize, I think, quantity over quality.
Yeah.
And they marketed a lot and got a lot of feeds. And so I was a new lawyer, much newer, and I was just given the cases, and that was my job. I was a salaried employee. It was like, okay.
Yeah.
He was like on a bus, a public city bus, and had fallen when they braked, something to that effect. And the guy was homeless, like clear.
Okay.
And then they start asking him like where he lived, and he starts going on this tirade about, this is in his deposition, about the different like trash, what are they called? The things that they lift up, right?
The dumpsters? Yeah.
Right. But then, and he had to take medication, which I'm very clear that there was no sobriety going on in that brain over there.
Yeah.
Plus probably some mental health. And so he went on this laughing tirade after a break, after he took some medication, and then he's offering testimony, and then he just stops. And he's like, I just peed my pants.
No.
And I was like, okay, I think we take a break.
In the deposition.
And he's sitting there like, I just peed my pants. And I was like, okay. So that's one fun little story. And then, it was that one was wild. But I had another one where the client didn't know about his deposition, another serious big drug use thing. And his deposition, he didn't know about it. I called him, he shows up, and he clearly had been very high on I don't know what substance.
Something.
And he went on the break to take a smoke break and got lost and never came back.
He just ditched in the middle of the deposition?
He just never came back.
Just went AWOL?
I'm pretty sure he just got lost.
Did you ever get an outcome for that case, or was it just...
No, we couldn't find him, and then I think it was a nominal result. Like, it was just like, okay, we need to get rid of this. It was really bad. So that was when I started to learn that selection in cases was very important.
Oh, yeah. All the crazy things come out in the depositions. So why don't you go ahead, introduce yourself, where you work, what you do, how long you've been doing it.
So my name is Larry Margolis. I'm an attorney, as most of us are here. Been doing it now for 29 years. Wow,
Nice.
Mackenzie, I'm getting old.
Oh, stop it. Just getting started.
So I have a small firm in Ann Arbor. We primarily, historically, I'm a criminal defense guy, civil rights guy, immigration guy. I do a lot of trial work, criminal trial work. That's what historically I've done. I've also maintained a personal injury practice as well. And so half my business is personal injury, civil rights, plaintiffs litigation, and the other half is pretty much criminal.
So why don't you go ahead and tell us the craziest case that you've litigated?
So I represented one of 4 doctors who were accused of healthcare fraud and drug diversion.
Yeah.
And it was at the time that the case was charged by the U.S. Attorney's Office, it was the biggest healthcare fraud case in the country. $500 million.
Oh, wow.
4 doctors. It was also one of my old high school friends that I knew very well who was caught up in this clinic that was charged. So it was a big case at the time, and we ended up getting acquittals on all counts for all the doctors, and it got a little dicey with the prosecutor's office, as these things can get. But it was a lot of fun. It was a 6.5-week trial. Every day you're eating, using the bathroom with the same people over and over and over. So that was. If you have any more specific, detailed questions about that case, I'm happy to chat with you. But it was an ordeal.
Absolutely. What are some of the key points of that stick out to you?
Well, we found that one of the agents, when I say it got dicey, one of the agents we believed was construing the evidence improperly, and so. In federal cases, federal trials, as you know this, John knows this, things come up in the middle of trial.
Yes,
so
they
at
do.
this particular case, I had to file motions to try to get the case dismissed on prosecutorial misconduct. I went after the agent for manufacturing testimony through one of his, quote, victims in the case. And it was interesting because this was an agent that would come every day. He'd bring his backpack. And he'd watch, he'd take notes, but then when I realized that he had possibly, I believe, manufactured evidence, he stopped coming to the trial. And then I made a big deal out of it with the jury, or with the judge, always outside the presence of the jury. And so I was the guy who, in the beginning of the trial, out of all the lawyers, we had 8 lawyers on our side. They had 4 or 5 prosecutors on their side. I was the nice guy who would bring little candies to the lawyers and was playing fair and nice with everybody, as I always would. But when this issue came up, they stopped talking to me, and people drew sides, and it got really difficult to communicate, and became very uncomfortable to communicate with the other side outside the presence of the jury. So what became started off being playing nice ended up not playing nice.
Yeah, so it goes sometimes. What was the
Yes.
outcome of all of this?
So the outcome was good. Acquittal on 56 counts. One of the prosecutors didn't even show up for the final. He ended up one ended up quitting the U.S. Attorney's Office.
Oh, dang.
Didn't show up for closing arguments.
Really?
And left the other senior prosecutor to hold the bag by herself. She is now a judge, this prosecutor. She was very distinguished, is very distinguished, and I'm just hopeful that she doesn't have a deep memory, because I have other cases in front of her too.
Well, thank you so much for sharing that case with us. I
No
appreciate you
problem.
talking with us.
So I'm Noah Hurwitz. I'm an attorney in Ann Arbor, Michigan. I kind of an interesting story, because about 3.5 years ago, I switched from the defense side, where I was representing big companies, to just representing employees in lawsuits against those big companies.
A lot of people come over from the defense side.
Yeah.
So tell us about the craziest case that you've ever litigated, whether it's settled or went to trial.
Right. Well, so in doing employment law, we have a lot of crazy cases, mostly because employment law has really interesting fact patterns, right? Everybody is going through a lot of things at work. Work brings up a lot of personal situations.
Oh, yeah.
And then when somebody loses a job, it really impacts kind of their identity and self-worth. And so we get involved and we try to fix those things. So the case that I'm thinking about that so far might be the craziest, the one that went wild, is we represented a young woman who got into a relationship with her boss. And what happens in these sort of cases in the employment context is there can sometimes be a fine line between a work relationship and a consensual relationship, and this is one where that started to blur. But what we look for in our employment cases is we look for when the boss is in a position of authority. Position of authority is kind of the phrase, the buzzword that we use.
Right.
Where that boss has sort of manipulated the standing of being a boss in order to forge a relationship with the employee. And so we've seen a lot of that. That historically has been sort of a common thing in workplaces, but really since the Me Too movement, that gave that sort of situation a voice. And since then, we've had some success helping our clients who find themselves in that situation.
Awesome. So you have any particular outcomes of any of those iffy situations?
Yeah, well, in this one, our client was actually working for this company for a number of years, and she started to be asked and solicited to sort of do a little bit more unusual things and stay after at a golf outing, stay after work a little bit. And eventually that did develop into a romantic relationship. And even our client took that relationship pretty seriously. She was married at the time, and it became a very sticky situation.
Oh, yeah.
But eventually what happened is she found herself in a position where she said enough is enough, and she had to push back. And when she started pushing back and when she started telling her boss that she wasn't going to, be involved in anything else with him, then it became a real issue.
Yeah. Were you able to help her out at all?
Yeah. She lost her job, and then when we went to the company and we pushed back and we fought for her rights, as an employee who felt that she was in this very vulnerable position and taken advantage of, and we were able to show from a causation standpoint that the likelihood is that she would not have lost her job had she kept up in the relationship with the boss. The company actually took her deposition and really attacked her and really, put her in a position where they showed her text messages that she had sent with the boss, showing that, she was a voluntary participant in this relationship, and they tried to use that against her. But fortunately, the law holds the company responsible when there's that supervisor relationship. It becomes a little bit more of a strict liability situation. So if that relationship exists and the relationship is one in which it's happening at work, which in this case it was, it gave us enough leverage to settle that case.
Nice. Well, thank you for doing the good work. Keep it up. And thank you for sharing your case with us.
Thanks so much. It was fun doing so.
Oh, absolutely.
My name's Jennifer Measel. I'm a personal injury attorney. I'm located in northern Oakland County. I've been handling strictly PI cases for about 20 years now.
Oh, wow. Wow. Got a lot of... So you must have some crazy case that you're able to discuss today.
Oh, yes. I can think of one in particular that comes to mind.
Why don't you go ahead and tell us about it?
Sure. It was a premise liability case against a bar.
Oh, those are tough.
Yeah, but listen. So the my client was in the back area where people were smoking, right? Because you're not allowed to smoke in the bar, obviously.
Right.
So this area was open to the public, and it happened to be in a very rural area, so the bar was on a septic system. And I don't know if you're familiar with what a septic system is, but essentially human waste is going into a containment system in the ground, right?
Oh, yeah.
Eventually, the septic needs to be cleaned. So the bar on this particular day was waiting for a professional service to come out and clean the septic tank, and had left the lid off in the area where my client, the plaintiff, and everyone else were traversing, right?
No. Oh, no.
So I didn't know a whole lot about septic tanks before I started this case, and I became a quick expert in knowing that I never, ever, ever want to see the inside of one.
Yeah, no.
My client had lost her ID and was looking around in the back where there was no lighting with this open septic tank. Now, the open lid covered an area approximately 2 feet by 2 feet. So...
I don't like where this is going.
Not a huge hazard, but my client happened to be tiptoeing along and just bloop, fell right in.
No.
And if she hadn't put her arms out in a T like that, this woman would have been fully submerged in human waste.
Oh my God! So what'd you guys do about this?
Well, I got an expert, a septic expert, to come out and take a look and give his opinion on whether or not the hazard was there for a certain amount of time. He said it was. The septic was in terrible condition. And, no one wants that case in front of a jury.
No.
No one wants that case in front of a jury.
No.
The way she testified about how she felt while she was in there, basically kicking her feet and trying to find somewhere to land.
Oh, no.
They settled that one pretty quickly.
My name is Laura Dearwa, and I work at Sam Bernstein Law. I've been an attorney for 17 years now, I want to say. I've been at Sam's office for almost 5 years. I did some insurance work beforehand. And so we try cases. We have premises liability, auto negligence, that kind of stuff.
So why don't you go ahead and tell me the craziest case you've been involved in?
So one of the most exciting trials I've ever had. It was my first trial at Sam Bernstein Law. It was about 3 years ago. And it was a very simple rear end accident. But my client had a lot of facial injuries and had 5 surgeries as a result of the accident.
Oh, wow.
He was an artist that did a lot of plaster work, and he had some neck problems and couldn't look up at the ceiling as a result of his injuries. So the offer was too low. We took the case to trial. It was like a 3.5-day trial, but the jury was unusually attentive. Every single juror that was on every single juror I had in the case had at least a college education.
Okay.
And a very notable CEO of a controversial company around here was on my jury.
Oh, wow.
So they deliberated for, probably a half of a day on Wednesday and a half of a day on Thursday morning. Anyway, they give me a really good verdict at the end of the day, and I'm very excited to celebrate. And the first thing I do is call my husband, and he had gotten electrocuted while I was waiting for the jury to deliberate. So I didn't get to celebrate with him.
Oh, my gosh.
Yeah, so it's not necessarily a case has gone wild. It's things that go wild in your life while you're trying cases.
The life of an attorney.
Yes, the life of an attorney.
So my name is Nick Colson. I'm a class action lawyer here in Detroit. I've been practicing for right around 12 years now.
Nice.
And always in the class action space primarily.
Oh, nice. So why don't you go ahead and tell me the craziest case you've ever been involved in?
So one that comes to mind is, as a class action lawyer, I don't get to try a lot of cases,
right.
But I want to stay ready to try cases because there can be a class action where it's really important to be ready for trial. And
right.
so I pick up cases pro bono or coming in at the last minute, and just to make sure I'm staying sharp with them. And so I tried a case in federal court here in Michigan, 2023, where I came in after discovery's already closed, so I don't get to make any record. And my client is a prisoner in the state prison system who's been representing himself pro bono, so he hasn't taken any discovery. I have almost nothing that I can use. And I don't get to even take depositions to sort of feel out what I'm dealing with in the case or anything. And so the case it's a tough case to begin with. It was a prisoner civil rights case, and my client was in prison for a drunk driving crash where he caused someone's death, but he was seriously injured himself. He broke almost every bone in his body, every bone in his legs, several ribs, his skull, his back.
Ouch.
Serious injuries.
Yeah.
And they wouldn't give him real pain medication in prison. And so for these civil rights cases, you have to prove deliberate indifference. It's not just bad doctoring. It's not negligence. You have to prove that they were deliberately indifferent to the serious medical needs of your client. So it's a really tough standard. So you match that up against the fact that the client had a background that made a lot of the jurors not necessarily love him.
Yeah.
And it was all, the whole case hinged on the testimony of the defendant doctor, who was one of the highest ranking doctors in the Michigan prison system. And I'd never laid eyes on the guy. The only thing I knew about him was his name and his resume, but I had no opportunity to take discovery or anything about this guy. And so the first day I saw him was the day that he came to testify at trial.
Great.
Where I had no idea what he was going to say.
Great.
And I'm standing there, and this guy walks into the courtroom, and I'm thinking that this guy must be lost because this is like the coolest looking guy I've ever seen in my life. He looks like a jazz musician. He's got like the super neat dreadlocks back and this really cool outfit on, and all of a sudden I find out, oh shit, this is the doctor. And like, this is not going to go well at all. And he proceeds to go up, and the judge took it out of order, so his counsel did his direct examination first, and then I get up on cross, and I have to prove that this guy, who is smart, eloquent, extremely cool seeming, was deliberately indifferent to the needs of my client. And some of the facts were good. They wouldn't give opioid pain medication to anybody in the whole state prison system unless they were basically dying of cancer and they were really, really close to death. And so our case was, look, if anybody needs opioid pain medication, it's this guy, it's our client. So I go through and I get some of the facts out of this guy, and he acknowledges that he's only ever given opioid pain medication to one person in the whole state prison system, because it all filters up to him, that he can think of, that didn't have terminal cancer and wasn't at the end stage. And I'm like, oh, that's a pretty good fact for us. And then the redirect starts, and his counsel asks him, what did you do to understand the population of patients that you were treating when you got this job? And he says, well, I was always taught that you should try to walk a mile in your patient's shoes. So the first thing that I did is I went down to the prison store and I used my own money to buy a pair of prison-issued shoes, and I wore them all day, every day for a year.
Oh, my God.
And I just looked over at the table. I'm like, we're fucked. And it turned out that we were, because it's very hard to find someone to be deliberately indifferent when they've done something like that.
Yeah.
So a really, really tough case, but just a fact that you're never going to get over. And the visual of this guy walking around in these shitty, beat-up prison shoes while he's treating patients.
That's crazy.
There's just no way we were going to come back from that. So definitely crazy in the sense that, like this, I knew the case was over.
Well, that made it easy for you.
Made it easy for the jury. We managed to keep him out for about 4 hours, but there was really just no getting past that fact.
Can you introduce yourself for us and tell us a little bit about where you work, what kind of law you do, how long you've been doing it?
Yeah, so I've been an attorney for almost 6 years now. I've been a plaintiff attorney for about 3 weeks. I was at a defense firm for my first 5 years, and then I recently came to Marco Law for the last few weeks. And it's been a big change, but I think all the defense work I did has been very helpful, coming on this side.
Oh, yeah. I know you have my old office.
I didn't know that, but I'll take care of it.
So can you tell us about one of the craziest cases that you've ever had?
Yeah, so I have a crazy case, but it's not crazy in the sense that somebody died or somebody lost their arms or their legs. It's more crazy in the sense that it's a simple case, but a recent law change made the facts a little bit more hard to argue. So when I was on the defense side, I was representing a grocery store, and this old lady, she wanted to celebrate her new job at Costco. She wanted to grab a bottle of wine, but the cleaning service are doing their waxing the floors. So she walks up, she sees the yellow tape, she sees the wine. It's only a few steps away. She lifts up the tape, takes one step, falls on her back, needs shoulder surgery, says her teeth fell out, all these
Oh my God.
all these crazy issues because she fell on the floor, you know? So you think it's a slam dunk case, she lifted the tape and went under, right? But in 2003, the law changed, the open and obvious law changed, where it's before, if it's open and obvious, if there's a puddle of water, you don't need a wet caution sign because it's open and obvious, right? There's no duty to exercise reasonable care because it's open, it's obvious. You don't step on the puddle, right? Don't go under the yellow tape. But the Candle case in 2023 got rid of that duty and turned it to breach. So now you have to look at the store. Did they breach their duty to exercise reasonable care with whatever puddle or cleaning services or whatever's on the floor? Did they breach that duty? And so, of course, what am I going to argue? Well, there's a yellow tape, right? What else do you want? It's a slam dunk case. Well, they argued no. They said the back end of the aisle wasn't taped off. So right, that was, and I'm like, oh, I didn't even think about it. Okay, so good point. So she could have walked all the way around, went, grabbed her bottle, and fell. Okay, and so we took a lot of depositions in this case, and so I represented the cleaning service and the store. So I had them testify. You know, what is standard protocol? They said, well, we don't tape off the back aisle. We tape it off perpendicular from this end and the front, because we have these big machines going back and forth, so that we can't have them lifting up the tape every single time. So she could have entered from the back end because it was taped off, but it was, oh, by the way, I didn't mention this is all on camera. So it's all on camera, and you can clearly see there's no tape, but you can't see the other aisles, if they're taped off or not. So all my guys said, it's protocol, we tape off those ends, but they couldn't say if they did it in this case, right? Also, there's customers going back and forth throughout the video. And so this was like an hour on the record, motion for summary disposition, and we're with the judge looking at every second of this video, somebody's walking in, and I'm like, well, that might be one of my workers, right? And he's allowed to go back and forth. And so we examined every worker, we examined every deposition to see if it's possible that she could have gotten to that spot a different way. And the judge said no. The judge said they did their job, there was no breach, and the whole case was thrown out.
Oh.
Yeah, and it was a big win because it was the first time I had to deal with this new law change, and everyone's thought, it's gonna be so easy now for plaintiffs to. Now that I'm on this side, I wish I lost that case, but it'd be so easy for us to win these open and obvious cases, but it's not. You still gotta, you still have a duty. You still can't breach it. You still have to take care of your customers. But yeah, we got the whole case dismissed, and it was a pretty good victory.
Thank you for sharing, Reno.
My name is Robin McCoy, and I'm an attorney. I've been practicing. It'll be 24 years in November. I specialize in criminal defense, family law, juvenile justice, and my dad and I have a firm in Washtenaw County, and we do wrongful death, personal injury, estate planning. And Dad's been practicing. It'll be 44 years in November.
Why don't you go ahead and tell us about the craziest case or client you've been involved with?
This is a hard question because I have done all kinds. If anybody that does neglect delinquency, juvenile, murder, civil, they know family law, there are all kinds of crazy cases. I think what resonates with me the strongest is I had a murder case. And so it was out of Inkster, and my client was charged with murder. He was looking at life in prison. And they did not have the an Inkster police. They had the state police, and they did a really sloppy job on the case. And so we start the case, and when you're in the courtroom, it can be an intense environment because this was a murder case. Someone died.
Yes.
One person died, and another person was a victim of a shooting, and they lived. So right before we even start picking the jury, there's a woman that howls. I think she was one of the deceased family members.
Oh.
She howls, and you're in front of a jury. And it was kind of just settling, but you kind of have to keep it calm because you're in a trial. And so what you usually have to do in trials is having to control your emotions, not necessarily reacting, because the jurors are looking at you and your client. You may have clients may get upset. And so this trial, I would say, went well because I had a client that was working well. We were working together as a team. And when you want to have success, if you're going to a trial or if you're wanting to resolve a case, it's important that you and the client have trust between the two of you.
Absolutely.
If you don't have that, it can go haywire.
Right.
I tell clients, I don't like surprises. Just tell me what happened. Here's a police report. What's your side of it? I don't like surprises, And so in that case, my client and I, we had a good rapport, and as far as the witnesses, they had it was all people. There was like a drug house in Inkster, and one of the witnesses was one of the other drug dealers that was in the house, and he said that he said that my client came in there and was doing some things, was shooting at him, but see, it was like crossfire because the deceased and the guy who was testifying, they were shooting back. And so so he said that my client was doing it, and then my client said that he had just pulled up there and he saw something happening. He saw a shooting, and then he left his car there running, and then he said he was able to go back the next day and go pick up his car.
What?
Which I was like, that is just weird. So anyway, the witness testifies, and he testifies about getting shot and that there's crossfire going back and forth. And then we went through all of the evidence, but the way the evidence was set up, it was just so sloppy, and it just wasn't very clear about. Right. For the prosecution, they were trying to say that my client went there. They didn't have any weapons. They didn't have his fingerprints. They just basically had one of the deceased was passed away. The other was living, but he was really sketchy about who did it and what happened. And so, and it was, you have to, when you're in a trial, you got to look at all your facts and you got to take advantage. If the police do a sloppy job with their evidence, with not doing fingerprinting or anything like that, then you just put that to the jury. And I put it to the jury, and then they came back and we got a not guilty. And then Inkster is a rough neighborhood. And so I just said to my client, just lay low, when I say lay low, because the family might have tried to come after him, and that's what the jurors said too when I talked to the jurors afterwards. And it was good that I could see that the jurors felt they could relate to my client, because sometimes they don't. Sometimes like when they're looking funny when they come out and they don't want to look at you, like they're mad at you, like look, I'm just trying to do my job. Right. But they were like really, they could identify with my client, and they said, we just hope he doesn't get popped tonight. That's one of my craziest cases.
My name is Jamil Murad, owner of Defined Law, which is in Dearborn, Michigan. I do primarily personal injury and criminal defense. Nice. I've done a few family law and probate cases recently, so I've been, dealing with those type of cases as well.
All right, nice. So, give us your craziest case or client that you've ever been involved with.
So, a wild case that I can think of most recently was a case that I recently took on, in which the injured party resolved a mini tort claim, or which they thought was a mini tort claim, and the defense attorneys and the insurance company actually tried to argue that mini tort was actually a bodily injury claim. So defense filed their motions, we filed our response, and quite frankly, I was baffled by the approach, but we prevailed in that, and luckily we were able to have the judge order that in fact it wasn't a mini tort claim, or I'm sorry, it wasn't a bodily injury claim, but rather the mini tort claim. The client called them before reaching out to our office, and this is something that I tell all clients, all people basically, do not deal with the insurance company before reaching out to a law office or an attorney to go over any of the documents that may need to be signed or anything for that matter without consulting an attorney.
My name is Dustin Hoff. I'm an attorney here in Michigan. I practice primarily in the Metro Detroit area, but we practice throughout the state. Personal injury, trial work, not as much as some other people, but get a couple trials a year.
Nice.
And
nice.
it's great. Love it. Can't complain.
Good. Love that for you. So go ahead and tell us about the craziest case or client you've ever been involved with.
Case or client? I don't know that I've had a crazy client or a crazy case, but I had a crazy situation now that I think of it. This was a trial I had maybe about 4 or 5 years ago. And they didn't depose the client ahead of time.
Oh.
And she is up on the stand giving testimony, basically how did this crash occur.
Mm-hmm.
And because there was no motions in limine on anything that she would have maybe said in a discovery deposition or anything like that, she was just left free rein. And she was saying all of the stuff that we wish we could say, talking about insurance, how she pays her premiums, all the other things that you're not supposed to say, but it was elicited by the defense attorney, and they never ended up objecting to anything that she was saying. But where it got really interesting is that she's getting very worked up. Mm-hmm. And I'm sitting there at the defense table, and when she came in, her nephew had brought her in, and he comes running up to the table and is like, "She's got a bad heart. You got to stop this," because it was starting to get a little heated.
Mm-hmm.
"You got to stop this. Don't let it go. I'm afraid she's going to die." And she starts, not hyperventilating, but getting heavy breathing.
Uh-huh.
And the judge leans over and kind of, calming her down. And finally, he just stops the examination and is like, "You're not asking her anything more." Really, really great judge, very empathetic to all witnesses. Doesn't matter, what their designation is.
Good.
So he does this, and she leaves, and as she's leaving, she's looking at the jury, and she's, "I'm sorry. I'm so sorry that you guys got..." Every single one of them are crying.
Oh, no.
And right after that, they asked for a break. And that was the turning point, I thought, in the trial that really shifted our momentum. Because up to that point, it was a lot of medical testimony, a lot of, kind of, I don't want to say boring stuff, but it was, their witness says this, our witness says that. Who do you believe? And then just hearing it from her, it was so impactful. But I remember, and so then when it went on to appeal, they were screenshotting the pictures of the judge, consoling her, and the nephew coming up there. It was quite a deal. It got affirmed, but that was just one of the more interesting things that I've seen in a trial. So,
well, thank you so much for sharing that with us, Dustin. We appreciate you being here.
Thank you, Mackenzie. Thank you for having me.
Yeah, so I'm Alex Kay. I'm an attorney at Marco Law.
Nice.
And I've been a lawyer for 3.5 years, doing plaintiff's work for the last 1.5 years now.
Beautiful.
Yes.
So go ahead and tell us about the craziest case or client that you've had the pleasure of dealing with.
Okay. A lot of crazy cases working with John. We get to see it all, as you know.
Yes.
Myself, I've worked on some pretty cool cases. One that comes to mind immediately is a trucking case that I worked on with John when I first started. A really serious crash on the highway, a nice young client who's about my age and had some life-changing injuries. I got to learn a lot from John on that case. Really, really good defense lawyers who also taught me quite a bit, and ended up with a great result for our client, which was awesome.
Is there anything else that makes this case crazy?
There were some complex facts about the trucking company, what they were hiding, and we worked really hard to uncover every single detail that we could for our client, and ultimately it made a big difference. So
Good. Got a good outcome?
Got a great outcome, and there's been a lot of lessons learned that I've taken with me in future cases.
So my name's Tyler Joseph. I work for the John Marco, and I have been practicing 8 years now. I've always done personal injury, civil rights, employment, in that order, mostly personal injury. I'd say I dabble in employment a little bit, but I worked for John back in 2018 for a short time. I left, and then I ended up coming back. So, if you want to try cases, there's no better place to be than Marco Law. So I've been here now 3.5 years-ish, so it's been good.
And I know you have a lot of crazy cases, so can you share one?
I do. So I had a case last year, and I guess I'd call it crazy. It's not too crazy, but it's more, really interesting how it all panned out. So I had a client who was a young girl. She was, I believe, 9 at the time, and she was crossing the street on her bike after school one day, and she got hit by a car, and she got knocked out. She had a TBI. The injuries were pretty severe. She ended up making a pretty good recovery, but it was really scary for 6 to 8 months afterwards. And the family went to no less than 6 or 7 attorneys. They all turned it down. The police report had the little girl at fault. They said she was crossing against the signal. She shouldn't have been in the road. It was her fault. Nobody wanted the case. So when the case came across my desk, I said, well, I got a little girl with a brain injury. I'll see if I can make something out of this. And what unfolded from there was pretty crazy. So I started calling the witnesses and asking them about the police report. Does this line up with what you saw? And I had 6 witnesses, and they all said that's completely false. The lady that hit her was either drunk or on some sort of narcotics. She was laughing at the scene. She was stumbling at the scene. She was slurring her words. It was the craziest thing I've ever seen. All 6 of these witnesses. So we take their depositions. They testify to all this. I take the deposition of the defendant. She denies it all. She says, I was fine that day. She came out on the road. I had the green light. She rode her bike into my car, is what she said. And I dug a little deeper, and she told me during the deposition that she had been meeting with a friend about 20 minutes before at a restaurant. And I found out who this friend was, and I looked into him. This individual was 30-ish years old. Mind you, she at the time was 60-some years old. And he had a extensive criminal history for not only dealing drugs, but manufacturing and distributing.
Oh, my God.
And so I noticed up his deposition, and that's where things got really, really weird. He didn't want to be deposed. He was very defensive. I asked him about his criminal convictions. I asked him point blank, did you provide the defendant in this case any narcotics? Did she take any narcotics? And he suspended the dep. He wouldn't go forward. And, at this point, I had a great theory. I had all these witnesses. I had this defendant who was meeting with a convicted drug dealer. I didn't have any hard proof that he had provided her drugs, but everything that everybody saw, it sure looked like she was on something. So the defendant driver didn't have a ton of insurance. And we had been making a demand for the full policy limits for months, and they kept saying, no, absolutely not. Your girl's at fault on the police report. We're not paying it. Even after all these depositions, they still refused. And we went to case eval. In Michigan, we have case eval, and that's where a panel of 3 attorneys, it's kind of a lottery of attorneys, they evaluate the case. And they put an evaluation on it over the insurance policy limits, which is kind of unheard of. And they still wouldn't settle. And so at this point, we got to maybe a month out from trial, and finally one day I got a call, and they said, hey, we'll pay you the policy limits. And at that point, we said, it's off the table. We've been asking for this for months, and we've just been ignored. And so this attorney lost his mind. He was offended by it, and he basically said, well, I don't know what you think's going to happen, yada, yada, yada. This is all the insurance we have. And lo and behold, a week later, they ended up paying that case evaluation award above and beyond the insurance policy limits. So I guess that goes to show you sometimes you do have to judge a book by its cover when you're looking at cases. But, if there's something in your gut that tells you maybe there's something more here than meets the eye, dig into it a little bit, and you never know what could happen.
Oh, yeah. Thanks for sharing, Tyler.
No problem. Thanks, Allie.
All right, everyone, that concludes it. I got to go back to the conference. So thanks for tuning in to the special edition for the first day of the Michigan Trial Lawyers Conference, Cases Gone Wild edition from downtown Detroit. We'll see you in another 2 weeks. If you or someone you know need help, please go to marcolaw.com or give us a call, 833-MARCO-LAW, M-A-R-K-O Law. We'll see you in another 2 weeks for another great episode of Cases Gone Wild.